Thanks for joining us at the Business Growth Cafe, where each week we select from a menu of topics for a focused discussion with an industry expert to provide insights that can impact your business's growth. With your host, Angelo Ponzi.
I am Angelo Ponzi, your host here at the Business Growth Cafe, and thank you for joining us. Each week, we select from a menu of topics that can impact your business growth to discuss with experts from a wide variety of disciplines. And today at the cafe, I'm excited to have Bob Yonowitz, partner of law firm Fisher Phillips, on our show to discuss changes in the California tax laws and how they can impact the growth of your business. Bob, welcome.
Thank you for having me.
Before we get started, why don't you talk a little bit about yourself and your organization so the audience can get some perspective on who you are.
So I'm a partner at the firm called Fisher Phillips. We are one of the nation's leading labor and employment firms. We represent companies all around the United States, big and small, in all of their labor and employment issues.
Okay.
I've been doing it for just about 31 years and have seen just dramatic changes over that time here in California, particularly, and all around the United States. Some good and some not so good for employers, making it pretty difficult for them sometimes to do business. But we try to do our best to provide practical guidance to them to navigate the minefields of labor and employment.
Fantastic. And hopefully we're going to give them some guidance today for those that are listening. Let's get started. This is a question I used to ask at the end of the show, and now I've kind of moved it to the front because I want to get some perspective. So you're a lawyer and at this law firm, national law firm, but you're also a producer, I think they call it when you're looking for new business yourself. So I'll call it as a business owner in a sense of your portfolio, what keeps you up at night when you think about your business growth?
So I would tell you of all the things that I've looked at over the last few years, as somebody that does have to make it rain in my organization, with increased competition in the legal community, there's a growing tendency for what I refer to as a race to the bottom. Lawyers will drastically reduce their hourly rates, and staff matters with attorneys that are inexperienced so they can still make their rates profitable. But they sacrifice quality. They sacrifice ingenuity and expertise in the name of trying to go ahead and present a lower hourly rate to their clients. The problem with this analysis is that clients are looking at the wrong thing. They shouldn't be looking at hourly rates. They should be looking at the cost of engagements. Somebody who's experienced and qualified can do something 2 or 3 times faster than somebody who's not, often with a lot higher quality.
Right.
And so what I really am trying to do to help myself sleep at night is to really communicate the value proposition to my clients, to be looking at the right thing, which is what's the cost of the engagement, what's the result that you're getting, and that's really how you measure value as opposed to just the drive to the bottom for the lowest rate possible.
Yeah, that's a great analogy. I think we know each other, and my history is working in advertising agencies and had the privilege of owning one over a 13-year period. And we used to have this debate with our clients all the time about value versus rate card. And I've told the story before, is sitting at a lunch, we come up with this great idea, client loves it, it's fantastic. We, send him an invoice for $25,000 and he flips out because in his mind, well, you were only together for an hour for lunch, so therefore it should have only cost, $250. And so we try to explain all the time. And I'm a true believer about the value proposition, if you will, and what's the value you get out of it as opposed to what the dollar amount is. And the other thing you said, I think, is really important, that is about quality. As an experienced lawyer, you can get things done at a higher quality and more efficient than someone that's driving at a lower cost that takes 2 or 3 times longer and not necessarily getting the quality out of it.
And I think it's important in that regard that it's about managing client expectations and helping to define the win for them every time that you wind up representing a company early on, because that's how I think they really can perceive value. If they understand why you're doing what you're doing and you take away all the smoke and mirrors and mystery, they don't usually question the value proposition because they understand what to expect. And as long as you deliver on what to expect, everything works out really well.
Right. Well, setting expectations is another interesting aspect of this. So I'm a company and I decide I need your services. Do you find that typically companies are proactive in kind of getting the head of the game to make sure you're managing their expectations and their employees, their issues with potential employees, or are they typically coming to you because there's a problem and now they're being reactive and they need help?
So Angela, the best way I would answer that is this. If they haven't been stung before, they tend to be reactive rather than proactive. They
Okay.
come to you when they have a problem. Once they felt the sting of liability by getting hit with one of these employment cases, they tend to be a lot more proactive,
Okay.
and they tend to be calling you a lot more often before they make decisions that can really affect their bottom line.
All right. So the smart ones are going to call you before they get stung.
I think always that's the case.
So when you think about all the different, I'll call them cases that you've been involved in, I mean, when you think about all these different businesses, where do businesses in California, if you will, and we'll focus on California because that's, you know, where you practice, get themselves in trouble when it comes to dealing with their employees? I mean, is there kind of this something you see over and over and over again?
I do. I think there are a series of common mistakes that that employers make. First and foremost, before I go into anything substantive, the most common mistake is to think that logic will give you the right answer when it comes to California law. Most of the obligations that employers have under California law are not necessarily intuitive. You either have to know what the rules are, or you're going to wind up tripping over yourself. But you know, I would tell you there's three common mistakes that I see repeat over and over again in the company life cycle. The first is the failure of employers to actively document discipline and termination and providing the legitimate, non-discriminatory, non-retaliatory business reasons for why they make their decisions. Sometimes they get bad advice and they hear, oh, I understand that the employee's at will. I guess I should just tell them you're being terminated because you're at will. And that's the worst advice in the whole world, because this is your opportunity to create a record of the legitimate business reasons for why you make the decisions you do. Those decisions should be documented and explained to the employee. I always use an adage that a good termination comes as a surprise to no one. If you've done it right by actively documenting performance issues or rule infraction issues during the employment relationship, by the time it's ready to go ahead and terminate the employee, they kind of expect it because you've set that record. A second one that I see repeat over and over again is the failure to maintain good timekeeping practices. With hourly employees, it's so important. With all the wage hour class action that goes on these days, they need to be having their employees review their time cards, making sure they're accurate. The managers need to review the time cards, making sure that the employees have taken their rest periods and their meal periods, and having the employees sign off on the time cards to make sure that they ensure that they're accurate. And then the last one that I see is just growing and growing right now is when you have employees that have disabilities. Employers are constantly getting it wrong on engaging in something called the interactive process. It's this conversation that they're supposed to have with their employees about how to figure out whether or not to accommodate them. And employers really need to take that obligation seriously, and most importantly, they need to document the steps that they're taking to try to show that they're being reasonable with the employee to try to accommodate their disability so that they can effectively work in the workplace.
Okay. Do you find that that's an interesting one, that companies are really laxed in that one and dealing with folks with disability and also anticipation of outside clients and people coming in and all that?
I think that there is a tension between their legal obligations and their business goals with a lot of companies in terms of there can be a frustration when you've got an employee that's out for a great period of time or can't do the job. There is a tension that exists with the company that they just want the work to get done.
Right.
And the law tends to be cumbersome in this regard because they have to be patient and they have to be able to work through the interactive process and figure out appropriate ways to go ahead and try to accommodate the employees so that they can do their job. The reverse of that is if they don't go through that process, all that's going to happen is they're going to take a small problem and make it a really big one, because they're going to get sued for disability discrimination when they don't demonstrate that they've gone through that interactive process.
Okay. All right. Some wise words there. I was doing some reading in at the end of the recent legislative session about 55 new laws affecting both public and private employers, large and small, were signed into effect by the governor. That will take effect on January 1st, 2019. There was about 8 laws on sexual harassment. What is the most significant changes in those laws that are really going to have an impact on employers?
It's a great question because as part of the Me Too movement, the California legislature, which tends to lead the nation, changes in the law tend to start in California and then bleed over into the other states. But coming out of this legislative session, to me, there are several really key developments that I think all companies need to be aware of. The first is in doing settlement or severance agreements with employees who have made allegations regarding sexual harassment, it's important to recognize that you can no longer have non-disclosure provisions in those agreements that prohibit the employee from disclosing the facts of the harassment. You can still have confidentiality as to the dollar figures that are paid, although that may affect the tax deductibility of those settlements. But what you can't do is you can't tell an employee you can't ever talk about what happened in the workplace. So that's a change. Another big change that has happened is that the liability has been expanded for third-party conduct that happens on company premises. The law used to be that if a third party like a vendor or a customer would come on the premises and engage in sexually harassing conduct, the employer would only be liable if the company knew about it and failed to take any appropriate corrective action. Now they've kind of eliminated that as a initial burden of proof. They've gone ahead and said that if a third party engages in harassing conduct on your workplace, you as the employer can potentially be held responsible for the acts of those third parties. And the reasoning for that is because they say that as the employer, you're obligated to maintain a safe workplace. And so just to digress for a second, what's so important about that is I believe it's very important that companies need to start having the dialogue with their vendors, with their clients, making it clear to them that we are a harassment-free workplace. We take these obligations seriously, and you have to comport yourself accordingly. Because if you don't do those things, the liability that can happen to a company for third-party conduct can be significant. And then the last one, the most troubling one for me, is there were a series of legislative, I'll call it mandates, findings that the legislature made to make it easier to be able to pursue harassment claims. One of the first ones is now, it used to be the law that you would look at the context in deciding whether something amounted to sexual harassment. You would look at the context of the workplace, meaning what happens in a construction site might be a different standard than what happens in an office.
Okay.
The California legislature has now said sexual harassment standard does not vary because of the workplace. It's the same standard regardless of the workplace. So whether it's blue collar, white collar, or anything in between, you can't say, oh, this is just a different kind of place. We get away with a different brand of attitude and conduct in this workplace. Now you can't. And on that same token, the legislature's come back and said single incidents, used to be that isolated epithets wouldn't necessarily rise to the level of severe and pervasive necessary to have harassment liability. Now single incidents, single stray remarks can be enough to trigger liability under the sexual harassment statutes. So it's more important than ever that training, that companies need to be making their employees, particularly their managers, aware of the rules of the road so that they don't get themselves in trouble.
Are there standards on how often employees are to be trained?
Yes, as a matter of fact, there's been some changes in the law there. Previously, the law had only put a training obligation on employers with 50 or more employees. That standard has been reduced now to 5 employees. That requires training. It has to happen every 2 years and within 60 days of onboard. At the same time, they've also expanded the training obligation. It's now 2 hours for managers and supervisors, but there's also a 1-hour training requirement for all employees, and that's something that didn't previously exist under the law. And if you don't comply with those training obligations, there can be significant liability exposure under the Fair Employment and Housing Act. One of the most, apart from the liability under the statute, one of the biggest follies in not doing that training is you are giving up an incredibly valuable defense that the company has to show that it takes its obligation to prevent harassment seriously by demonstrating that it trains its managers and employees about their obligations in regard to workplace conduct. So all I can tell you is the time that it takes to do training pays dividends well beyond that time in terms of protecting the company from potential future liability.
Is there a reporting mechanism, or is this really protections? So we're saying mandatory training and things like that. Do the businesses now have to report that back to the state that they're complying, or does this really come out in the case of a lawsuit?
There is no reporting to the state requirement. On the other hand, it's very clear that you need to have record keeping to demonstrate that the training took place. We typically, when we do training, as we do for many of our clients, one of the things that the managers will do is not only will they sign harassment policies at the training, but they're going to sign off on a sign-in sheet and receive a certificate of completion that's going to go in their personnel file. Because in the event of litigation, we want to be able to provide evidence that they got the training, they sat through it, and whether they learned it or not, it wasn't for the fact that we didn't try to teach them.
Right. Well, yeah, I mean, it obviously, I could make this statement, the more employees, the more opportunities for these kinds of situations, but really one employee alone could cause an issue to bankrupt an organization.
I think when you recognize that the amount of liability that can befall an employer, particularly in California for sexual harassment, can be in the hundreds of thousands, if not millions of dollars of potential liability for a single claim. These can be some of the most existential threats to a business if you're not doing the things that you're supposed to be doing. And remember, Angela, the most important thing is if you get rid of all the law and just remember one thing. If you want to avoid harassment in the workplace, it's ladies and gentlemen treating each other like ladies and gentlemen.
Absolutely.
And that's all you really need to remember. If you wouldn't do it in your place of worship, if you wouldn't do it in front of your mom, don't bring it into the workplace because it can hurt if you do.
Yeah. Well, again, you're throwing out some of those numbers. They certainly, as this show is about business growth, can certainly head you in the other direction. One of the other laws that and I've heard about this is about the ability for an employer to ask a candidate about their salary. So if we can clarify for the audience, they can not ask you about your salary history, but they can ask you expectations. Could you define some of that for the audience?
Sure. So the way the law changed here, and actually this is one of the few areas where it was helpful for employers. Prior to this year's statutory enactment, that's effective as of January 1, there was a little lack of clarity about what exactly you could or couldn't do. It was clear that you couldn't ask about salary history, but the way that employers had been getting around it is they wouldn't ask salary history. They would just ask, well, what are your desires? What are your expectations? They were doing that without knowing whether that would or would not violate the statute. So now the legislature clarified that and made it clear that with applicants, you are allowed to ask them the expectations question. Not what have you made in the past, but what is the salary range that you're expecting here, or what are your salary demands? It's also to remember that this law regarding the limitations on inquiring about salary history only applies with new applicants, not with existing employees in the workplace. The other thing that the new statute did is it made it clear that applicants can only ask about company pay scales once they've actually had an interview. And this is a big relief to employers because you had a lot of plaintiffs' lawyers going fishing to try to drum up Equal Pay Act claims where they were trying to show perhaps gender pay disparity by going ahead and making inquiries of companies of their pay scales where there wasn't even an applicant. And so now it's clear that companies don't have to reveal that information about pay scales unless somebody's actually sat in the chair and taken an interview.
Okay. All right. Well, thank you for that. The other thing you mentioned, and I certainly know this as an employer, Atwill. And I think it's a little confusing to some of the folks out there that what that really means. I mean, it's just, you can decide, I just don't want to work with you anymore, you're gone. So to your point you made a little bit earlier about documentation and really preparing, because is Atwill as clear a line as it sounds, or is it there's gray area in there when you start thinking about Atwill?
So the Atwill doctrine is alive and well, but people need to understand what it really means. Atwill means that you can terminate somebody with or without cause at any time without notice, but you cannot terminate them for improper reasons like harassment, discrimination, retaliation. So the reason I talk about documentation is it's not because the employees aren't at will. They are at will. The reason why we want employers to do documentation for discipline and termination, where they identify the legitimate, non-discriminatory, non-retaliatory business reasons for their decisions, is because when there's silence, the plaintiffs and their counsel, they make up stuff as to what the reasons were.
Okay.
And so if only one person's speaking at the microphone, you get the wrong answer. And by doing accurate documentation, you're setting a record at a time when you're not being threatened with a lawsuit.
Okay. So Susie Q gets let go and she comes back and says it's because of harassment, yet she has no proof or there's no documentation of that. They're just kind of making it up.
They're making it up, and if there is no documentation, they can assume that maybe it is. But on the other hand, if you've identified these business reasons, you're one step ahead of the game because you can say, no, that's not the reason. We told you the reason. We gave you a warning. and we told you the reason, and then we gave you a termination, and we told you the reason.
Okay. Let's move on to another section that's near and dear to my heart, and I think probably a lot of folks that are listening, and that's the independent contractor or 1099 person. Yeah, there's always that. So I've been in, as I said, in the advertising world and the marketing world for a very long time. I have been and hired 1099 folks, and there's kind of some litmus tests that we're always concerned about when we hire folks. But that law has also changed. It made it a little more difficult. So let's kind of probe into that a little bit and maybe lay that foundation of what still exists and what's the new test, if you will, the smell test I like to call it, when you're thinking about hiring a 1099 person.
You bet. And there has been some dramatic changes in the law. In fact, actually, one of our partners from our Sacramento office just sent out a blast today that the legislature is now taking up some potential statutes to codify a decision that came down called Dynamex. So prior to Dynamex, the standard for whether somebody was an independent contractor was based on the IRS 20-factor right of control test. And it would be a variety of factors ranging from, are they acting like a separate business? Have they incorporated? Do they have a license? Do they have insurance? Do they have other customers? And there were about 20 factors, and you would look for a totality of the circumstances to determine whether somebody qualified. Starting back in Massachusetts, Massachusetts had adopted something called the ABC test. And in the Dynamex case, the California Supreme Court did the same thing, and they adopted this ABC test. And this ABC test, you have to meet all of the requirements. And so the A test is one that talks about not exercising control over the independent contractors.
So they get to pick their own hours. You're not telling me when to show up. I'm telling you basically when I'm going to work. Okay.
And you know, I will tell you that. Actually, you know, before I tell you what I'm going to refer to as the Plumbers Test, let me go through the other two elements. There's a B element, which basically talks about whether or not this service that the contractor is performing is in the ordinary course. And then the C element is kind of like the old 20-factor test of, are they looking, feeling, smelling like they're an independent business?
Okay.
Most of the litigation is going to be around the B test, whether or not the services that the contractor is providing are within the ordinary course of business of the company. I kind of take this all down, and it's interesting because Dynamex actually mentioned this, not because they were quoting me, but they just used an identical example. For years, I've been talking about something called the Plumbers Test. And the Plumbers Test is this. Plumbers are true independent contractors, and the reason for that is this. When your pipe's leaking in your advertising and marketing business, you go online and you look for an advertisement for a plumber. They tell you when they're going to come. They come with their truck, their tools, their abilities to diagnose the problem and fix the problem. Mm-hmm. They come into your place, you say, hey, my pipe's leaking. They say, thanks very much. They go ahead and they diagnose the problem. They use their materials to fix it. They give you a bill and they leave and they go off to another customer. And their plumbing services have nothing to do with your advertising and marketing business. They're a true independent contractor. In contrast, when you're using like an outside salesperson or somebody that should otherwise be characterized as a part-time employee or a fractional employee, but the services that they're performing are the same services that you're reselling to your customers or clients, there's no way you're going to meet the B test. And under Dynamex, if you don't meet all three, you're not an independent contractor.
Well, that's interesting and scary all at the same time. And I think, you know, there's a lot of organizations and a lot of people that are independent contractors, and I know there's been a lot of seminars and webinars on this. Actually, this might be a good one in itself to really focus on that, because I think there's a real lack of education when it comes to that area. So I'm looking at my engineer. Are we getting down to the wire here?
Yeah, he's outside.
All right, we got our next host coming up. Man, this flew by. It really flew by. I still have other questions, which means, Bob, I'm going to have to get you back on the show again. So we'll wind it down. One last thing. We've talked about a wide variety of topics today, and again, thinking about the things that can impact business growth. So I'm going to let you pick 2, 3 recommendations or suggestions, that help keep people on the right path.
So if it was my business and I was looking at the things that I could do to prevent liability as best as I could, I would be doing 3 things. 1, all employees should be signing mandatory arbitration agreements with class action waivers. You don't want to be in front of a jury if you're an employer because they are not juries of managers and owners. They tend to be juries of employees.
Your peers.
Second, You want to make sure that you've got detailed harassment policies and you're doing the training that we talked about earlier in the presentation. And third, just remember this. As a company, the main thing you want to be doing with your employees is demonstrating transparency and fairness. You want them to know the rules. You don't want them to be surprised. And when you make decisions, you want to be transparent and clear about the decisions that you're making, and you do that through effective documentation of discipline and termination and through effectively publishing to them the rules of the kingdom, so to speak, in terms of how they're supposed to be conducting themselves in the workplace. If you can demonstrate fairness and transparency in the way you deal with your employees, you're going to avoid a whole ton of liability under California law. Well,
thank you so much. This has been a great conversation, and I'm sure the audience is going to get a lot of great stuff out of here, a lot of nuggets, I like to call it, if they pay attention. But let's tell the listeners how they can reach you and get a hold of you.
Sure. So again, my name's Bob Yonowitz. I'm with Fisher Phillips. You can take a look at our website, which is www.fisherphillips.com, or you can send me an email at ryonowitz, that's YONOWITZ, at fisherphillips.com.
All right. Well, thank you so much again for joining us today. So thank you out there for joining us at the cafe. You can find out more about me, read my blog, see my videos at theponzigroup.com. You can connect with me on LinkedIn or Facebook, and you can subscribe to our show at thebusinessgrowthcafe.com. We are now on iTunes, Google Play, Spotify, Stitcher, and coming soon to SoundCloud, iHeartRadio, and many other podcast platforms around the world. Join me next week for lunch at the Business Growth Cafe.
Thank you for listening to today's discussion at the Business Growth Cafe with your host, Angelo Ponzi. Take a moment to subscribe to this podcast and visit our website at www.businessgrowthcafe.com. Read Angelo Ponzi's blogs at www.theponzigroup.com.
Now, Crowder's showing employment law, two different ones that I think you'd be perfect guest for. And I'll pass it on to them here. One is specifically about these PAGA lawsuits,